That's why protecting proprietary data in discrete automotive manufacturing industry is vital with regard to federal state regulations. As connected manufacturing becomes more common, industrial intellectual property, process secrets, engineering designs become vulnerable. The data protection is not an IT problem. It's a critical part of your company's strategy and a part of your legal obligations, national security, and global competitiveness. Automation makes manufacturing more efficient, but it also introduces digital vulnerabilities. Cyber threats can use these systems to steal proprietary data or disrupt production. Manufacturers must ensure they are compliant with applicable laws and protect their environments. Breaches can result in litigation, loss of intellectual property, or regulatory fines. That's why legal teams need to be aware of potential risk. IST. The Federal Information Security Modernization Act, or FISMA, mandates that federal agencies and their contractors implement strong information security programs. Compliance is mandatory if your company is part of a government supply chain. NIST helps by developing the cybersecurity framework and SP 800 series. These guides help manufacturers create strong, reliable security programs to protect sensitive systems and help mitigate cyber risk while complying with federal law. National security systems, or NSS, are critical components of defense, intelligence, and military activities. It's vital that these systems be protected according to CNSS policy and to guide from NSA and rules for classified handling. DAFARS and NIST SP 800 to 171 impose strict controls if your company is contracted to support defense. Breaches of NSS systems and operations could impact our nation's defense, so secure architectures and access limitations are not optional, they're mandatory. Laws. States like California, New York, and Virginia are also enacting their own data protection laws, such as the CCPA and SHIELD Act. These laws can go beyond federal regulations, requiring breach notifications, encryption, and consumer data rights. Suppose your company is operated in multiple states. In that case, you need to monitor state-level requirements and adapt to new ones as they emerge, especially as state-level enforcement becomes more active. Proprietary data. Several federal laws help protect proprietary data and personal data. The Economic Espionage Act is designed to deter trade secret theft. The Computer Fraud and Abuse Act criminalizes unauthorized access. The Defend Trade Secrets Act allows companies to seek civil relief. These laws form a legal barrier against cyber intrusions and insider threats. Know these laws and apply them to your business to make your company more resilient and able to defend itself in court. Legal risk. Civil and criminal legal risk can arise quickly if you don't adequately protect data. A civil risk might be the failure to comply with contractual terms for data protection. A criminal risk might be intentional or reckless handling of restricted data. Warning signs might include frequent compliance violations, disregarding audit findings, or signs of unauthorized access. It's critical to detect early to avoid legal exposure. And compliance. The landmark cases of Riley v. California and Van Buren v. United States have shaped the legal definition of digital privacy and access. Courts closely examine how companies store and secure data, especially if that data is tied to an individual or intellectual property. These cases influence how regulatory authorities will enforce the law. It's essential for legal and IT teams to keep track of these decisions. I'll challenge you because this presentation was not just about the law, it was about leadership. Will you be the one to understand these laws, choose the right framework, and ensure your company fulfills its obligations? You can lead your organization to compliance, resilience, and a competitive edge with the right tools. Training and attitude are also essential. You'll have to decide, will you be the one?